Number 83, Delgado versus State of New York. Counsel?
Your Honor, if I could reserve 2 minutes for rebuttal.
2 minutes.
May it please the Court, I'm going to get right to the point of this matter with the unconstitutionality of the 2018 law that created the Committee on Legislative and Executive Compensation, and a matter that I believe is a matter of first impression for this Court, which was the enabling language of that law that permitted an unelected committee to make what was called recommendations.
What do you mean when you say it's a matter of first impression, given we have the judicial accountability litigation?
For this
court?
This Court, the Court of Appeals. So what functionally what the law did was it took some recommendations by an unelected committee that became law as of January 1st, 2019, without any further action of the legislature. And
But why do you need that action? I mean, you've got the original statute, the legislature has already made a determination, it's provided these factors, it's given guidance, and then the legislature does have an opportunity to reject those recommendations. So you've got legislative action on the front end, legislative action on the back end. Sounds like more legislative action than you would have had if you were just passing a statute.
Except that's not true, because whatever the committee did, these recommendations they did, in addition to having what's called the force of law, also superseded inconsistent provisions of the legislative law, sections 5-A, and 169.
Yeah, but my point is that the legislature, because they get an opportunity to reject it, right? That why isn't that, if not the spirit within the language of the Constitution? Why isn't that good enough?
Yeah, because the Constitution has language and specific steps for how a bill becomes a law, and within the spirit of the Constitution isn't enough. So what you're talking about, Your Honor, I believe is, if anything, what happened was the 2018 Act was a bill that had future action to be done, and what we in our brief call a non-final bill, which is not something that the legislature is allowed to pass under the state constitution.
So can I probe over here, sorry, can I probe the contours of your argument a little bit? So suppose the thing's set up the same way that it's set up, but what happens is the legislature says for 2019, the compensation will be $110,000, and the committee for the each of the successive 3 years will adjust it based on inflation, let's say. Is that constitutional or not constitutional?
Not constitutional
Okay,
because...
and what if it says based upon the consumer price index? Still not constitutional?
That's a good question.
I try to ask them.
Fortunately for me, that's not the case here.
Yeah, but I'd like to know, I'm trying to see where the delegation comes from. Is it a lack of specificity? And if you get to some point where it's specific enough, there's not a problem? Or is it from something else?
So it's all of the above. First of all, it's the mechanism. The mechanism was one by which the committee made its recommendations.
Let's stick with my good question.
Okay, I'm getting to your good
Okay.
question. It was self-executing. So let's say there was a cost of living allowance built in there. Maybe that's self-executing enough that it passes constitutional muster, that there can be increases to pay during the legislative term.
Well,
That's a
let's say it said the
possibility.
CPI, right? Is that sufficient enough?
Yeah, and that'd be great if it
Okay,
was
but
our facts.
there are several different CPIs, right? There's for urban, there's a whole bunch of them. And beyond that, the CPI is created by a federal government organization, right? Bureau of Labor Statistics, which sometimes changes the inputs to the CPI and sometimes changes the weights to the CPI. So ultimately, you're having a delegation to some non-elected group.
So assuming that all works, I think that would be a situation where we're skipping a step to what was actually the assignment of this committee. But if those were the guidelines, then you're getting into the kind of what's not really being questioned here, the cases that established, Levine v. Whalen and so on, that established, okay, you set up the guide rails.
So it's not the non-elected so much, it's the specificity is not tight enough. Is that the problem?
Yes, if
Okay.
you can get past the fact that this committee is making recommendations that supersede existing law
So
without the legislature taking any further steps.
Your argument that the quote-unquote reasonable safeguards and standards that were included in the 2018 legislation were not specific or comprehensive enough?
My argument is that there were essentially none. There was a non-exhaustive list of factors that the committee could decide to use as appropriate to think about the prevailing adequacy of compensation of executive officers and legislators and statewide elected officials, and then determine whether there was an increase in those salaries that was warranted. That's the whole policy question. That's the whole ball of wax.
Counsel, it seems, what I'm struggling with a bit is this case doesn't really fit within our separation of powers jurisprudence, right? Which is legislature delegates an overbroad policy decision to an executive branch official or agency. That's not what happened here, right? So who's on this committee?
It was supposed to be the chief judge who declined to serve. I'm not sure why. I don't know if I know why. The 52nd state controller, maybe the 24th city
So specific
controller,
individuals.
and then the sitting city and state controllers.
Right, but in their individual capacities, right? The 52nd controller is not a controller, it's a specific person, right?
Yes, yeah.
So my issue it seems to me the issue that jumps out to me is, can the legislature delegate to this type of committee, which is not an executive branch committee or agency, this type of authority?
I say no. I think they can create legislation that has commissions that do certain things that fit into the body of administrative law that sits out there. The point of this case is, this isn't within that body of law.
So what is the rule? Since you acknowledge that commissions can be delegated with authority, we have case law that sort of defines the standards for how you delegate authority to a commission. What is the rule to be applied in this case that shows us that this was an overstep?
So, under the existing body of law, administrative agencies or commissions can develop rules and regulations that have the force of law. That force of law is under the law. There's an existing statute, they're within the scope of that statute.
Well, we have that here. There's an existing 2018 enactment that creates the
Right.
commission and gives it its marching orders.
Sure. But then, those rules and regulations don't supersede any other laws. They stay within the bounds of that law.
But here, there was a statute in effect for them to be paid, for these particular officers to be paid. The only thing that the committee was to consider was the amount.
That's correct.
So how is that doing something impermissible?
Because what they did in that instance, let's go with the commissioners. They took 6 tiers, made them 4, gave the governor discretion in 1 or 2 of the tiers that didn't exist before. What they did, though, was what they did then supersedes existing law. So this committee went and did these recommendations that you actually can't find anywhere very easily, and they are now the law. So on the books, anywhere you look, Westlaw, the Legislative Information Service, the Senate website, case text, anywhere online, Executive Law 169 has 6 tiers of commissioners still. That's not been changed, even though this purports to have changed the law, superseded the law. They're outside of the bounds of what is typical administrative law.
Counsel, you would, I think, even with your analysis, agree that if what the legislature had done was adopt a statute that set up this committee and required that it provide recommendations, both to salary and actually these other choices that the committee made, and then the legislature adopted them, you would not object to that process, right? Or rejected them. You would not object to that process, correct?
I wouldn't, no. I mean, they've had 4 years to do it. They could moot this lawsuit today, and I'd be happy.
Yeah.
And my
So
clients would be happy
your
with
point
that.
is that instead of having a system by which, if they don't act, the legislature doesn't act, the recommendation has a force and effect of law. And what you want is for them to affirmatively vote up or down, whichever way they're going to vote on it. Or, well, vote up, right? They could just not vote on it, and that means it's not in effect. That is where the rubber meets the road, right? For
Yeah,
your
but
argument?
I guess I'm going to go out on a limb a little bit here and correct you when you say force and effective law,
ahead.
because my friend here is going to keep talking about force of law. What they did was law. According to the law, it supersedes
No, what I'm
conflicting provisions of
asking you,
laws.
along the lines of some members of the court have given hypothetical, I say, would you agree that if the statute simply set up the committee, authorized it to provide the legislature with these recommendations, and then the legislature had at that point to act, you would say that's fine, correct? They can pass enabling statutes to
Yes, Your
design
Honor.
whatever body to give them recommendations and do what they want.
That's correct,
So
Your
your
Honor.
issue is not setting up the committee. Your issue is that they don't then take some affirmative act in
Correct.
response to the recommendation.
It's the executing mechanism.
Right. So then the case boils down to whether or not the legislature can set up a mechanism where if they don't act, it has the force of law.
And I say they can't, the Constitution says they can't.
Because they always must act. That's your view.
That's, yes. And don't forget, I don't really think the governor should be able to prospectively surrender the governor's veto power, which is also an important part of our constitutional process.
With respect to both supersession and the veto, the original 2018 bill, legislation, contained the supersession language right in it. It was certainly contemplated in the minds of the people who passed the bill that these numbers would supersede the numbers in the old statute. And one would presume when the governor signed the bill, he noticed at the time that there was no veto provision in there. So how is this not all pre-cleared under the statute?
Because it can't be, because the way the statute is designed, that makes it a non-final bill, and the legislature can't pass non-final bills. They essentially left blanks to be filled in. We want you to decide, and they gave the entire policy decision to this committee, decide whether or not everybody should get raises or not. Make that decision for us, and then fill in the blanks, and whatever blanks you fill in are going to supersede the existing law where the numbers are already written down.
No, it's actually, then we're going to look at it, you're going to give us the recommendation, we're going to look at it, and we're going to decide whether or not we disagree, and if we do, we're going to reject it.
Yes, or we're
Actually,
going to do nothing. and
What
it's-
the way the law is written.
Right, or we're going to do nothing, and it's going to self-execute and
Yes. Yes.
become law. So back to you, Judge Rivera, back to your original question. This happened subsequently. I participated in the campaign, public campaign finance case, Hurley, in Niagara County. That judge said, no, correctly, there needs to be legislative equivalency for you to change the election law. There wasn't. He struck down the statute, and weeks later, the legislature took basically everything that that committee had done and passed into
But in the
law.
Niagara County case, the committee was given the authority to commit to create new law, fully create new law, and it didn't have the parameters that were set forth here.
They had quite a few rules that they were supposed to follow in what they were doing. I believe in that.
So you're saying this case is identical to the Niagara County?
I'm not saying it's identical because there was an extra component. They were tasked with drafting new legislation and were given the power for anything that they did that conflicted with existing election law, it would supersede. I do believe that language was basically the same in
And
both.
still, because of the distinction between the two, it doesn't make a difference here. What this committee did, you say, still caused the legislature to improperly give up their powers.
That's correct. I would say that maybe the public campaign finance law was this one on steroids because they got to, draft new laws as opposed to just supersede. But nevertheless, what happened was exactly what should have happened. A committee made some recommendations. The legislature actually enacted the law. Regardless of anybody's position on the merits of that, that's the way it should be done, and that's the way this should have been done all the
Counsel.
way through. Thank you.
Good afternoon, Your Honors. My opposing counsel's major point seems to be that the committee is somehow superseding pre-existing statutes. But as the Chief Judge pointed out, it was not the committee that did the superseding. It was Section 4, Subdivision 2 of the Enabling Act that superseded the pre-existing statutes.
Let me ask you.
Palladino,
I'm sorry.
why not just apply the definition for a law that's in the Constitution, a bill passed by both houses and signed by the governor?
That precisely describes the Enabling Act. It was the Enabling Act that was passed by both houses of the legislature.
So then they have free reign? So as long as you comply with Boreali on any topic, if there's an enabling act that allows it, anything is a go?
No, Your Honor, you have to satisfy the requirements in Levine versus Whalen, all of which are satisfied here. We have the articulation of the basic policy, namely that salaries for public officials should be adequate.
But that's a different issue. You're giving it to an executive branch agency, and you have to retain the big policy picture in the legislature. But let me give you a hypothetical. There's a legislature, they want to do tort reform. It's getting to the end of an election year. They can't get around to it. There's a gubernatorial election, all the seats are up. They lose the gubernatorial election, the parties are going to change, different parties coming in, different governor, not going to do tort reform. They do this. They pass a law in the interim, and they off-board the process. They give it to a committee and say, same thing, you can overturn rules, a common law, whatever you want, and if we don't act, we the legislature don't act, then that's going to become law and supersede statutes. They do that, they come up with this thing, it comes back, bam, it's the law, there's a new governor sitting there, powerless, right?
Well, I assume that this law that you're hypothesizing does set forth adequate policy.
All
adequate standards.
that off-boarded, that offshore legislative machine there, that has the same authority you have here, different topic.
I think that would be a lawful delegation if the governor who signed the law was politically accountable for signing that law.
He's
The
gone.
new-
He
the
or
new
she is
governor-
gone. New governor. New governor says, you're overturning statutes that are passed on the books. Where's my veto? One house below can say, no, this is going to have the force of law now. And there's no process there's no process for reviewing that by the executive branch.
Governors get overridden all the time. Bills become law over their veto.
That's a process that we have in the Constitution. This is not.
Yes, it is, Your Honor, because if this new governor doesn't like the new state of affairs, that governor can propose legislation to overturn what this committee in your hypothetical
But
did.
that's maybe a fix to a problem, but my concern is the problem that's been created by having a process for changing the law that doesn't have to go through the constitutional bill passing. And we've talked about commissions and other things, but those have to, as I think your adversary was saying, one, they have the force of law, but they're overridden by statute. And two, I think even the commissions have to comply with the Administrative Procedures Act, which I don't think this committee did.
Well, my opponent did raise a SAPA claim. He lost in that claim, and he abandoned it, so that issue is
I'm not
not.
saying that's the claim you're going to win or lose on, but it just shows you how different this is from the ordinary process. I mean, they don't have to comply with SAPA, right?
Well, Your Honor, they do have to follow the guidelines that were laid down for them. They have to act consistently with their enabling legislation. This is not unprecedented. This is just like Center for Judicial Accountability. It's just like the Berger Commission
Well,
statute.
it's a little different from Berger, isn't it? Because in Berger, the governor had the ability to disapprove it, no?
No, Your Honor. There was a legislative veto, a very questionable legislative veto process by which the legislature could have disapproved the recommendations of the Berger Commission. That was doubtful in light of Chadha, assuming this court would follow the federal model in that respect. What is similar is that there was enabling legislation that established the policy, established the guidelines, and reserved the right for the legislature to review the report of the committee before it became law and pass a new law to modify or abrogate. But in all other respects, it's essentially identical.
It's not an administrative rule. I mean, there are several differences. It's not an administrative rule, right, in the truest sense of an administrative rule. This committee comes up with recommendations that will become law unless the legislature rejects it. right?
Well, I don't see much of a functional difference between this and a rule of an administrative agency, other than the fact that rather than having an ongoing administration.
Well, you're right. If a statute says that any administrative rule or a particular administrative rule is going to go through this same kind of legislative thumbs up or thumbs down, but generally that's not the case, right? You have an enabling statute, authorizes the administrative agency to pass appropriate rules with appropriate guidance given to them, and they do, right?
Exactly, and rules do not have to be submitted.
But I'm saying about usually without coming back to the legislature. That's what's happened here.
That's true,
My
but.
misunderstanding.
and then-
And although I think the hypothetical Judge Garcia's posed presents a tremendous obstacle to you, I guess there is a difference between the legislature delegating an entire subject area of law versus something discrete like the amount of the pay, because the pay, they're entitled to a salary, that's constitutional. They're not deciding whether or not you get paid, right? They're deciding the amount.
Well, that's right. I think in Judge Garcia's hypothetical, the scrutiny might be greater because of the scope of the delegation is so much greater.
Well, it sounds very much like early federal laws that knocked down exactly that kind of legislation, where you were delegating an entire area, no matter how much you tried to narrow an entire area of law versus this, which is, we're just talking about the amount of money you paid. You've already made a decision, right? It's a constitutional entitlement to a salary. You're just deciding what's the number. I mean, I think the problem is that you've decided up front that you're going to let them decide the number, and then once you see the number, you'll decide whether or not to reject it. That's his argument, that no, the only way this works is the legislature has to decide on the number first. It's not that someone can recommend it and then they just reject it. The legislature's got to decide that number.
But this wasn't just a number, right? It was, they changed the tiers, right?
Well, that's right, but think about what the tiers did. The tiers.
No, but I'm saying, where would we draw the line? So would we say you can offboard your legislative authority? And this isn't a separation of powers. I think a lot of what we're mixing and matching here is I'm giving my legislative authority to an executive agency. We have case law on that, very different. That's not what happened here. You're giving your legislative authority to this group, and they're going to come back and you're going to pass it through a means that's not the regular bill passing. So if you're saying, okay, you can do a number, what more than the number can you do? You can do the number, plus if you need to change the tiers to get to the number, you can do the tiers. What else could you do?
Well, the scope of the delegation is going to be important. In your example with the tort reform, obviously, there's a tremendous number of policies that are implicated there. You would presumably engage in more exacting scrutiny of the adequacy of the policy articulation and the standards.
Policy articulation, to me, is executive branch. We keep the policy, we give the rulemaking authority to the executive branch, we have cases that look at that. Here, to me, is something very different. It's the authority to make law and how that law is going to have the force of law. So you've delegated that authority to this committee in a way with parameters around it, but then within that, this thing comes back, and unless both houses agree that they don't want to do this, it has the effect of law and it supersedes within the realm of the delegation. Where do we draw the line on when the legislature can offshore that role?
Well, there can be constitutional restrictions on delegations. For example, in Article 16 of the Constitution, there are express limits on the legislature's authority to delegate the taxing power.
So absent that kind of express limitation, they could do this as long as the delegation kind of lists a relatively narrow area.
Presumably, yes. I mean, this court, at least to date, has not adopted what's, I guess, being worked on at the federal level, this notion of the major questions doctrine, or it's too big a deal doctrine.
Again, that's an executive delegation. Those cases didn't involve Congress setting up some type of other authority that then would come back. The only thing I could think of as an analogy is the rulemaking authority, like the federal criminal rules, the rules of evidence, which have this type of enabling act, but I believe the Supreme Court has said the legitimacy of that is somehow tied to the independence of the judiciary, and these are inherent authority rules related to the judiciary. This is very different, right? So
The same exact mechanism was approved at the federal level in the Pressler case, where the executive made a recommendation that acquired the force of law unless overruled by Congress. And I would point out that we don't have a unitary executive. So the fact that, I think that this is in the executive branch. It is doing an implementation. And under Section 18 of Article 3, the legislature is expressly allowed to create commissions for special purposes.
Why do you say this is within the executive branch?
Because it's implementing rather than creating policy.
What
I
control
don't
of...
see that. Aren't they just choosing? They're just choosing. 'Cause,
The-
Do you agree that the legislature could have made every one of the choices that's in the recommendation itself? Without any recommendations, they could have debated it amongst themselves?
Well, of course, but
Okay.
a valid
Do you-
delegation doesn't depend on a court thinking that the legislature had a good enough reason to do the delegation. It's a
Well, let me
question of
ask you this.
authority,
Do you-
not wisdom.
Is there anything for us to draw from the fact that the language, constitutional language is to be fixed by law as opposed to be fixed by statute? Does that matter at all?
Well, my
help
opponent
you,
thinks
hurt
it
you,
matters,
does
but
it
he's
matter?
wrong. I mean, it is true, I agree with my opponent that in 1948, when
Well, I'm just saying, it could have said statute, and the only people who pass a statute are the elected officials in the legislature.
right, the Constitution could have been worded in such a manner as to preclude a delegation, but it was not. The intent of it was to transfer authority from the Constitution, where salaries used to be, or legislative salaries used to be fixed, and give them to the legislative branch with the consent of the governor. But what's lacking is any evidence that that was intended to preclude the legislature from delegating that authority, just like it can delegate just about any other authority as long as you
Mr.
have...
Palladino, I'd like to cite a general term case, so we're going way back to 1871, Healy v. Dudley. That case held that, indulge me for a minute, that, quote, "The Constitution, in providing that the salaries of county judges shall be established by law, confines the power of fixing such salaries to the legislature. The court further reasoned that when an act is to be done according to law, or a thing is to be established by law, we all understand the law intended is a law passed by the legislature and not some inferior body acting under powers conferred by the legislature." I think in your brief, you didn't make a distinction between fixed by and established by, so why not just apply this?
Well, I don't agree that the legislature lacks the authority to delegate the authority that's been given to it. It was pursuant to law that these salaries were established.
But when the amendment was being passed contemporaneously with that, there was some discussion about the legislature's power being checked by public opinion, because if they overcompensated themselves, the argument went, the public would vote them out. So doesn't sort of offloading these decisions to this committee circumvent that entire check on the legislature that was contemplated?
No, Your Honor, because anyone who's paying attention realizes that it was the legislature and the governor, through the enactment of the 2018 law, that created this independent body and gave it the power to decide whether public officials should get a pay raise. So if the public doesn't like what the committee did, they realize that ultimate responsibility for those actions lies with the legislature and the governor. They do not evade responsibility.
Let me see if I can follow up on Judge Garcia's concerns a little bit. In the typical case where we're delegating to an executive branch agency, what we're concerned about is the improper transfer of legislative power to the executive branch. With me so far? Mm-hmm. Okay. And we don't, in that circumstance, worry that the executive is being cut out of the process. We actually are worried that the executive is having too much power in the process, right? It's a balance that way. If we're transferring to something that's an independent committee that is not within the control of the executive, we're not worried about the executive having too much power in that balance. We're worried about the legislature abdicating some of its legislative responsibility. For example, my 24-year-old daughter, who could have just as easily been named in the legislation as the people who are named there. She might actually do a good job on it, but that's another matter. In thinking about how much we are willing to allow in the way of delegation, if at all, should we be looking for tighter restraints in the amount that is delegated, tighter controls around the delegation, if it is not to the executive branch, but is rather to some sort of independent committee?
That certainly sounds like, in theory, a valid concern. I think that those concerns would be satisfied here by the level of detail in this statute. And in this case, I would also point out that the governor signed on to the process that created this body. It might be more problematic if, let's say, this legislation was created over gubernatorial veto. I would point out that, what happened here at the Supreme Court is that it was found that this independent body did go too far, and the judiciary stepped in, and that was an additional check by looking at the enabling legislation, looking at the guidelines, and concluding you were not conferred authority to supersede provisions of the public officers law. But I appreciate Your Honor's concern, and I do acknowledge this isn't quite like the typical situation, but if you just substituted this committee for an administrative agency, let's say it was put in the executive branch, and these recommendations were just called regulations, and putting aside the SAPA process would have kicked in. I think here the statute intended to supersede the SAPA process. Regulations are not submitted to the legislature for approval. They can at any time look at them and overrule them. So the fact that they're allowed to go into effect isn't a problem in that respect. And I think that there are sufficient checks here, because the legislature could have always passed a new law and overridden the recommendations, just like it can at any time step in and overrule an administrative agency's rules and regulations.
To go back to the overstepping of the delegation, you were asked a little while ago about the tiers. What is it in the enabling legislation that you view as authorizing, that goes beyond just setting a number, it actually changes the pay structure for those commissioners? Could that potentially have overstepped the delegation?
No, Your Honor, because first, ask yourself, what was the purpose of the old tiers? The old tiers were in service of adequate compensation. There was a judgment that at that time, all of the commissioners in the 6 tiers performed relatively the same scope of duties and responsibilities, and therefore they should get the same salary. The committee found that that was outdated, that there had been shifts over time in the relative...
That sounds like a quintessentially policy determination.
I would disagree, Your Honor. I think it's a subsidiary policy choice. The overarching policy is adequate compensation, and the tiers were in service of that. My opponent has it backwards when he says that I have to point to something that specifically authorized the rearrangement of the tiers. The real question is it in furtherance of the overarching policy? And if the answer is yes, then the body was allowed to make...
Could they eliminate all the tiers and say, get rid of the tiers?
Sure, they could have just gone commissioner by commissioner and said adequate compensation. Imagine, like in this case, the only real shift was one commissioner got moved from old tier A to tier C. I think he was the head of the gaming commission. And one commissioner went from B, that was Department of Financial Services, to tier A. That's because there had been shifts in their responsibilities over time. Under my opponent's view, if we were stuck with the old tiers, we would have had to have overpaid the gaming commissioner and underpaid
No, you
the
could have
commissioner of the
changed,
Department of
you
Financial
could have
Services.
changed the tiers by actually enacting a law and having the governor sign it. I mean, that's
There
an
was a
option.
law that authorized that because the overarching policy is adequate compensation, and I don't see what the tiers do other than
They're changing
achieve adequate
They're
compensation.
changing the tiers much more than for those 2 commissioners. They're changing them into the future, right? I mean, they don't just apply, the new tiers don't just apply to those 2 commissioners. They apply to anyone in the future, right? They've changed the law.
Pursuant to authorization from the legislature, furthering the overarching policy of adequate compensation.
I mean, there's 2 features about the tiers, right? And I took from one of your earlier answers that you were saying, for example, let's take tier C, which is 140 to 160,000, I think. That if they had simply said, okay, all these people we've put into tier C, we're going to not say tier C, we're just going to list the names of these jobs and say for each of those it's $140,000 to $160,000. That you're not really, the tier is just a shorthand way of identifying commissioner by commissioner what the committee has decided is adequate compensation. right?
Precisely.
That's the first part of what you said. There is a second part, though, to Mr. McDonald's argument, which is that it should have said 140 or 150. It can't say 140 to 160 because that is then delegating to the executive the power to pick fix the compensation. How
Well,
do you
that was
respond to
what-
that piece of it?
The committee was allowed to consider the need to attract talent, and I gave the example in my brief of you want to hire your clerk, if you just had one salary you could pay, that would limit your choices, but if you have a range, you can hire either less experienced or more experienced. And it's similar here, if you give the
Yeah, but
appointing...
then how is that fixed by law if it's not a number, if even the committee doesn't come up with a number?
Well, Your Honor, the commissioners are not subject to a fixed by law requirement. The members of the legislature are, and the Attorney General and the Comptroller are,
Okay.
one under Article 13, Section 7, the other under Article 3, Section 6. These commissioners are not state officers named in the Constitution, so you don't need to have them precisely fixed. So that's the short answer to that. But again, I would just remind, what is the policy that these tiers represent beyond simply a shorthand way to achieve adequate compensation? It's simply a subsidiary policy choice, and to have required the committee to adhere to the old tiers would have prevented the committee from fully achieving the legislatively declared policy, because they would have had to, assume that these commissioners were doing the same job they did 20 years ago, when in fact, over time, some of their responsibilities have expanded and some have contracted.
Thank you, Mr. Pelley.
Thank you, Your Honor.
What, if anything, is your response to this last point, that the commissioners, with respect to the tiers part of this, the commissioners are not even, let's call it this way, protected by the constitutional provision saying fixed by law?
Certainly. So I agree that the commissioners don't need to be fixed by law. That's the starting point.
Okay.
But there was a reason that the legislature originally did the 6 tiers of commissioners that the people supported through their votes for their legislators and so on. And that needs the same equivalency in legislation passed by the legislature changing those 6 tiers. And especially because they had never before given the governor discretion to make hires. That's nowhere described in the 2018 law to give the executive branch even more power and discretion. It may be a good idea. I think it is a good idea. But that's a policy determination that's a good idea. And on top of all that, I think there's likely follow-on effects from all this. So you take tier 6 and move it up, and you move these, you make these progressions in the tiers of the pay of these commissioners. There's follow-on effects for the employees below them and the salaries that are expected to be paid to the people who are deputy commissioners and so on. So that's a big question for the legislature to handle, not through some sort of vague thing to say, discover what's adequate, and then decide whether or not anybody's warranted an increase based on what is your determination of adequate. And by the way, we're not going to give you any guide rails on this. We're going to list a bunch of factors that are non-exhaustive for you to just go about your business. And the committee sort of proved the point by going on its own merry way with its holistic view of legislature compensation, putting income restrictions on legislator pay, and deciding that legislatures are full-time employees.
So let's say we agree with you. Is then the only way the legislature and the governor could pursue this particular route that has interested them in the past and that they are arguing in support of now is either to seek a constitutional amendment or to pass a statute like you regularly pass a statute and allow for a gubernatorial veto if that's what the governor wants to do? Is that the only options, or have I missed one?
I don't know. I don't know if there's like some mechanism to be done where you pass a law that causes, that is effectively a repealer and a replacement of some nature where they can adequately do things with proper restrictions and turn it into an administrative. I don't know, but because that's not the question here. The easy answer is pass a law. The other easy answer is this is not the way it's done, this 2018 law, and maybe there's something in the middle.
When you say pass a law, as in pass a statute, you mean they could either have made the decisions themselves.
Correct.
Or set this framework up, but they're just recommendations, and then they would take those recommendations and do whatever they need to do to have it pass as a statute, allowing for a gubernatorial veto.
Right.
Do I understand that?
Yes, that's correct. And so, there was not actually a SAPA
The
claim.
governor vetoing what the legislators get paid.
Right. There was not actually a SAPA claim in this. SAPA was a question asked to illustrate that nobody can identify what it was that this group did, because it wasn't rulemaking, but because it was lawmaking. Just to quickly address a point from earlier, the Berger Commission, to clarify, that commission was undoing certificates of need that were already part of the Health Act. So the health commissioner health commissioner or the public health council, whatever, had issued certificates of need to all these facilities. The Berger Commission was looking at reducing the volume of services and so on within the existing statutory framework. So it was going to eliminate certificates of need. There's no argument here with the current body of law on delegation doctrine and whether it's been too broad in some interest where it's just the public interest or something like that, because we don't get there with this case. We don't get there with this case because this group made new laws that superseded old laws, and it had no bounds on it anyhow, even if it could be considered part of that delegation. There was nothing constraining it, and by its own actions, it illustrated how nothing was constraining it.
Thank you, Mr. Catano.